Good morning. I'd like to acknowledge that we are gathered on the traditional lands of the Kaurna people. This session is a refresher for WHS legislation in South Australia. I've titled it Familiar Principles, New Approach, and my name is Tony MacHarper from SafeWork SA. When we're talking about the new laws, just a little bit of background for you. In South Australia, the new work health and safety laws started on the 1st of January 2013. They were based on the national model work health and safety laws developed by SafeWork Australia, a Commonwealth statutory authority. The whole aim of national model law was to provide workers in Australia with the same standard of health and safety protection, irrespective of where they worked or what they did. And allied with that is the aim of consistent compliance and enforcement arrangements across Australia. That is, when various inspectors go out in various states or territories, that they are working off the same policy approach to ensuring compliance and, if necessary, enforcing compliance with safety laws at workplaces across Australia. So in terms of the consistent principles that form part of the direction of this presentation, it's important to remind you that the laws apply to all industries, all workplaces, including the Crown, that is public sector workplaces. That the health and safety duties, including the primary duty of care to people in workplaces, really hasn't changed that much at all. It's very similar to what we've had for the past 25 years here in South Australia under the Occupational Health, Safety and Welfare Act that was developed in the early 1980s. Worker representation is still a feature of the Act, as is the need to consult and encourage participation via health and safety reps and committees. The role of the regulator remains, that is, in this state, SafeWork SA, and inspectors continue to have enforcement and compliance powers. There is beefed up protection for workers from discrimination because of their role in promoting and ensuring health and safety in the workplace, and we'll spend a little bit of time on that further in the presentation. We retain regulations and codes of practice. These were a feature of the previous Act, and whilst they've been modified somewhat, they remain features of the new laws in South Australia. Finally, our consultation arrangements, particularly for the Minister for Industrial Relations to receive advice in relation to work health and safety through a advisory body, that continues. It simply has a different name. So what are some of the new elements that we have to consider in relation to the new health and safety laws? Firstly, the concept of the person conducting business or undertaking, which essentially replaces the definition that we used previously, which was the employer. Officer duties are new, and I'll be discussing these things in a little more detail as we go through the presentation today. Protections against discrimination or coercion, clarification about the situation for volunteers, some changes to health and safety representatives' provisions, but fairly minor. Work health and safety right of entry, I'll be covering that to some degree, but there is more information available through SafeWork SA on that. Enforceable undertakings, which are a feature in a couple of other states, are now in our laws, and also the capacity for any decisions of an inspector to be internally reviewed. This was something that was available on an administrative basis prior to these new laws, but now it's set in black and white law, and people have the opportunity to request that any decision of an inspector be reviewed by SafeWork SA. Okay, so in relation to the person conducting a business or undertaking, this is a new concept. The primary duty holder is the person conducting business or undertaking, and previously as I described to you just before, this was formerly the employer. A PCBU, as we refer to it as for shorthand, can be either an organisation or an individual, depending on the setup. Businesses are usually enterprises that are conducted with a view to making a profit. They tend to be in the private sector, and they are ongoing. Undertakings are those organisations that are set up not normally for profit or not normally primarily commercial in nature. So, for example, BHP, Proprietary Limited, is a business, whereas there may be many community service-based organisations that are undertakings. They are not primarily there to make a profit. Nonetheless, they employ people, they have workplaces, and so they are captured by the Act, as they were under the previous Act. Okay, so an employer will be a PCBU, and the whole point of the PCBU concept is really to try and capture and recognise all the different types of working relationships that we have here in South Australia. These have changed somewhat in the last 20 or 30 years since the previous Act was put in place. It really is meant to cover everyone who is employing or who is at work. And the whole thing is designed to try and remove the argument and ambiguities around whether a particular person or organisation is a PCBU. All of these types of bodies, that is contractors, subcontractors, franchisors, labour hire companies, are captured by the Act and are regarded as PCBUs. So what does a PCBU have to do? Well, really not a great deal more than what employers had to do under the previous Act. They have to ensure, as far as is reasonably practicable, the health and safety of workers that they engage or cause to be engaged, or workers whose work is influenced or directed by them while they're at work. And also other people, like customers in a store or visitors to a workplace, who are, if you like, connected because of their presence in the workplace as connected with the work. That has not changed. Those types of duties, in terms of the primary duty, hasn't changed. I just want to spend a few minutes on the reasonably practicable concept, because it's something that a lot of people are not familiar with, but it's something that's been with us in the old law and continues over to the current Act. A lot of the duties in the Act, whether they are in the Act itself or whether they are regulations, are qualified by the term so far as is reasonably practicable. And in considering that, you have to think about two things, essentially. What can be done, in other words, what's possible to do in the circumstances in relation to health and safety, and whether it's reasonable to do it. Taking that a little further, here are some of the things that you need to think about when you're determining whether something's reasonably practicable. You have to look at the likelihood of the hazard or the risk actually occurring, the degree of harm that might arise as a result of that occurring, what you know or what you reasonably ought to know about the risk and the ways in which you can actually eliminate it, whether that method is actually available and suitable for the particular circumstances you're looking at, the cost, including whether it's grossly disproportionate to the risk, although cost should not be the primary factor at all when considering these things, and also the degree of influence and control that you actually have over the whole situation. A new concept in the Act is the concept of the officer, and the officer is taken from the Corporations Act, the Commonwealth Corporations Act that applies to companies and similar organisations. And so that, under the WHS Act, means either someone who's captured by the Corporations Act or an officer of the Crown, that is a government department or agency, or an officer of a public authority, primarily local government and statutory authorities. And when we're talking about an officer, it's very important to realise that the type of person who's going to be regarded as an officer for the purposes of the Act is someone who makes or participates in making decisions that affect either the whole of the organisation, that is the business or undertaking, or a substantial part of it, okay? So it's those people who are making the top level decisions, the executive group, the managers who have got the capacity to really consider and take decisions for the whole of the organisation or a substantial part of it. So just in case there are anybody here who or listening who are simply line managers, health and safety, industrial relations, HR, advisors and so on, you won't generally be regarded as officers for the purposes of the Act unless you are in a large organisation perhaps and are an HR director. So you're part of the executive team, you're helping them, in fact, part of the decision-making process, then you may well be officers. Simply because you have officer in your name, such as fire officer or police officer, does not make you an officer for the purpose of the Act. In relation to the duties of workers, it's important to note that workers continue to have duties just as employees did under the previous legislation. First of all, what do workers have to do? Well, they have to continue to take reasonable care of your own health and safety. You've got to ensure that anything that you do at the workplace doesn't adversely affect the health and safety of others. You need to comply with any reasonable instruction from the person conducting the business or undertaking, and you have to cooperate with policies and procedures in relation to work health and safety. Those things are virtually identical to the requirements that were current up until 1st of January this year. Turning now to the duties of officers. Officers have to exercise due diligence in order to ensure that the PCBU of which they're a part of complies with duties or obligations under the Act. And when we're talking about due diligence, which is the same thing that applies to company directors generally, it really means keeping up to date with work health and safety issues and being proactive in making sure that the PCBU that you are an officer of meets its work health and safety obligations. And again, there's quite a lot of information available in relation to duties of officers. I'm just covering it in a broad sense this morning. So in terms of the actual actions that officers need to look at in relation to due diligence, bearing in mind that due diligence is a continuous thing, it's not a point-in-time thing. You have to acquire and keep up-to-date knowledge of safety matters. You have to understand the nature of the organisation that you're an officer of in terms of the hazards and risks that the activities that it routinely undertakes entail. You've got to make sure that the organisation's got the resources and a process to actually identify those risks and to minimise any harm that might eventuate from them. You've got to make sure that you've got a process to receive and consider information about incidents, hazards and risks, and to respond to that information. Not just simply get a report, but actually consider the report and be able to put into train actions that are required to deal with anything that's in the report that suggests that there's a problem in relation to health and safety in the organisation. You've got to make sure that the organisation actually has a process for complying with any relevant health and safety duty or obligation. And importantly, you have to be confident that the organisation has got the ability to verify the fact that all these things are happening, that everything's in place and it's operating. Okay, so it is important to do that because it is one of the things that SafeWork SA inspectors will be very interested in when they're looking at an organisation, either responding on the basis that there's been an incident, or they may be responding to a complaint, or they may be doing it as part of a routine compliance audit. Either way, and of course there may be others outside SafeWork SA who are also interested in your management of health and safety at the organisation, whether they are your own risk consultants, insurers, work cover, whomever. Important to bear in mind that due diligence is a continuous concept, not a point-in-time one. As a consequence of adopting model laws, the previous requirement to actually nominate a responsible officer for each organisation is not included in the Act. That's essentially been replaced by the officer arrangements. We know that this was a particular concern to volunteer associations under the previous laws, and I'll just say something about volunteers in a moment. The thing to bear in mind is that in relation to officers in an organisation, the responsibility is a collective one for all officers. However, individual officers can be taken to task in a legal sense for a failure to actually undertake their duties properly. In relation to volunteers, the situation in relation to volunteers is quite clear, and it is clarified under the new laws. There were some ambiguities in relation to volunteers under the previous Act, but essentially there's no real change from the past. The main thing to realise is that if you are part of an organisation that can be defined as an entirely voluntary organisation, the Act doesn't apply to you. Common law principles still apply in relation to safety, but the Work Health and Safety Act doesn't apply. That's only for those organisations that don't employ anybody. Okay. For example, if you are in a sports club and you have people employed, perhaps you have a person who is attending to catering or a bar on a routine basis, then if you're employing that person directly, then the club is captured by the Act. They are a PCBU. If, on the other hand, you have a club or an organisation that doesn't employ anybody, but simply, when required, gets contractors to undertake work, then they are likely to be a voluntary organisation and not captured by the Act. There is information available on our website and the SafeWork Australia website in relation to volunteers, quite detailed information. Consultation is a key issue in relation to the Act, and the Act is very clear in relation to this. The PCBU's obligation is to actually work out how it's going to consult with its workers, and it has to do that in a way that involves those people. So how to consult has to be something that is not merely the decision of the PCBU or its management, but it has to actually work out a scheme of how it's going to consult with its workers on an ongoing basis. And the key areas, key times for consultation are when you're assessing hazards, when you're identifying hazards and assessing risks, when you're proposing changes in the workplace that affect health and safety, and when you're making decisions in relation to work that involves health and safety matters. There is also a requirement which is explicit in the new Act in relation to multiple duty holders, because in the Act more than one PCBU can have a similar duty, particularly if there's more than one PCBU at a workplace. There's an obligation to consult, to cooperate and coordinate, that is between the PCBUs. So, for example, if you are running a shop in a shopping centre, but the centre is managed by an organisation, the shopping centre management organisation, then you have to consult with that organisation in relation to the matters that affect your workplace. Okay? Clearly, in a shopping centre, some aspects of the building and so on that it may impact on health and safety are going to be the responsibility in the first place of the shopping centre manager. But you as a PCBU employing retail workers in your store, you have an obligation to actually cooperate and coordinate and communicate around the areas of overlap. And obviously this can be done in terms of the way in which you go about consulting. It's fairly flexible, but the key point is that you have to take steps to actually do the cooperation, coordination and communication. And you obviously need to involve your workers in relation to that. There is a lot more information available from a SafeWork Australia guide on worker representation and participation in relation to these issues. Health and safety representatives have been a feature of our workplace safety laws in South Australia since the mid-1980s. The provisions around health and safety representatives really are quite similar. They're a little less prescriptive in relation to determining work groups and conducting elections, but again there's information in the SafeWork Australia guide that I referred to just previously. There is more flexibility around work group formation, so you can have work groups that have people who work at more than one workplace, or people carrying out work for two or more PCBUs. You can negotiate and agree in relation to the position of people in managerial positions. Under the former Act, health and safety representatives, once elected, could issue default notices in relation to certain matters at the workplace. They've been carried over. They're simply called provisional improvement notices, or PINs for short. Health and safety reps in this state are able to receive training 5 days in the first year, 3 days in the second and 2 days in the third. That's a little more generous than some of the other jurisdictions. And that was one of a small number of amendments to the national model laws that were made in the South Australian Parliament prior to its passage late in 2012. In relation to transitional arrangements for health and safety reps, because of course we didn't want to have everybody's term as a rep suddenly cut off simply by virtue of the fact that we were changing the law. The appointments are recognised under the new laws, and for 1 year everyone can exercise everything that all the powers that they had under the old Act, under the new Act. However, and this is very important, particularly for any PCBUs with reps or for health and safety reps, they've only got to the end of 2013 to attend the one-day bridging course, that is the refresher course, which updates you in relation to the new laws. If you don't, then you won't be able to issue provisional improvement notices or direct unsafe work to cease. That is post 1 January 2014. So it would be very prudent to enrol in that bridging course if you've not done so already. There are in the new Act, if you like, more specific provisions in relation to discrimination and coercion for health and safety reps and other people involved in work health and safety at the workplace. The whole idea is to really encourage people to take an active role in health and safety. And so there is a prohibition on discrimination or coercion of anyone at the workplace in relation to health and safety matters. The Act sets out a list of prohibited reasons, and most of those involve planned or actual participation in activities in relation to health and safety. It's illegal to treat anyone less favourably simply because of their involvement in or taking action into work health and safety issues. Now, of course, as is the case with a lot of provisions in the Act, the word reasonable is used in the black letter law. That really provides an ability, if you like, to not simply assume that any behaviour, any activity is acceptable under the name of health and safety in the workplace. But for most people, they're going to act reasonably, and it's really just to prevent a minority, if you like, from taking advantage of the legislation in a way that wasn't intended. So depending on the circumstances, the provisions relate to either criminal law offences or civil law remedies. So, for example, criminal law applies if the safety regulator takes action in relation to something that's occurring in the workplace that could be discriminatory or regarded as coercive. Equally, civil remedies apply for individuals who want to seek some sort of recompense through the Industrial Relations Court if they have been treated unfairly. This can be compensation, reinstatement or re-employment. So that applies to, in terms of the activities in the workplace, that and the, if you like, the discrimination applies to things like being employed, getting a job there in the first place, or to being promoted, or being given overtime, or some other, if you like, entitlement, which is withdrawn or refused simply on the basis of the person's involvement in health and safety matters. Another thing that's new in our Act, but which did exist in every other state and territory in Australia prior to work health and safety laws coming in, was right of entry. And so the Act introduces union right of entry in South Australia for work health and safety purposes. The way in which this is organised is generally consistent with right of entry provisions under the Commonwealth Fair Work Act, and the Industrial Relations Commission of South Australia, the registrar there, is the authority that actually issues right of entry permits and deals with any disputes around right of entry permits. There is more information available on our SafeWork Australia website, and also the SafeWork Australia website and our own SafeWork SA website. But essentially, a union official who has a right of entry permit, bearing in mind that they have to undergo training in relation to health and safety before they can be granted a permit, they can inquire into a suspected contravention of the Act. They can also inspect employee records in relation to a contravention, and they can consult and advise workers in relation to health and safety. Now, there are some caveats around this. It's not a free-for-all in terms of entry into workplaces. While prior notice isn't required to inquire into a suspected contravention directly, there are specific procedures around notifying SafeWork SA, if at all possible, in advance of the entry. And SafeWork SA will quickly assess and may send an inspector to attend the workplace at the same time as the entry permit holder. So there are specific procedures in our Act in relation to this. Irrespective, an entry permit holder has to, as soon as possible after getting entry, advise the PCBU of the fact they are there and why they are there. And if they want to actually inspect documents or consult with workers more generally in relation to health and safety matters, as opposed to a very specific contravention, they have to give at least 24 hours notice. And that's similar in terms of record inspection, as is the case in the Fair Work Act. Another new element of our Act is the enforceable undertakings. And whilst it is not likely to apply to a whole lot of PCBUs, it does give the regulator an option that previously didn't exist in South Australia in relation to how it proceeds in terms of a breach of the Act or regulations. So essentially, an enforceable undertaking is an agreement between an alleged offender and the regulator to implement specific actions in order to improve health and safety where there's been a serious breach of the law. They really are an alternative prosecution. If there is a breach of an undertaking, once it's entered into by a PCBU, the regulator has got the option to go back to the court and have the undertaking enforced. It's an idea which allows the regulator to, without resorting to a full-scale prosecution, to have the PCBU actually undertake activities and spend resources to remedy a problem. In the more serious breaches, the regulator will continue to prosecute. We always have that option, but enforceable undertakings have been shown interstate to work quite well in some instances. And it does have the potential to alleviate the concerns and the impact of legal proceedings on small businesses, on workers, on victims, and of course, particularly on their families. The other new thing that I'd draw to your attention is the fact that people can request an internal review, and there's a number of reviewable decisions that are listed in the Act. The aim is to really provide greater degree of accountability in relation to the regulator's decisions, and to really, over time, really fine-tune inspector decision-making. The regulator has to publish reasons for decisions following a review, and that's done normally by a letter to the person who requested the review. If the internal review decision doesn't satisfy the applicant, they have the right to go to the Industrial Relations Court and seek an external review. That facility was in the previous Act, and there was generally an administrative procedure in relation to internal reviews. Now it's in the law, and we have had quite a number this year, about 8 or 9 so far. So that is something new. It's obviously a learning process, but we believe that it's going to assist our inspectors over time in relation to their decision making. Regulations. Regulations continue to be a feature of our laws. The regulations include things to do with authorisations, licences, for example, asbestos removal licences, licences to perform a range of high-risk work tasks. They relate to workplaces generally, facilities at workplace, first aid, personal protective equipment. They relate to chemicals, things like lead, asbestos, safety data sheets, and major hazard facilities. There are also regulations covering other hazards like plant manual tasks, noise, working at heights, remote and isolated work, confined spaces, and working with electricity. There are also specific regulations in relation to activities such as construction work, occupational diving, and mining. The key thing to point out in relation to those regulations is that there are transitional provisions. So some of the regulations which were, if you like, new requirements, there's been a transitional period of 12 months for a lot of those, and those regulations come into force directly on the 1st of January 2014. Again, there's information on our website in relation to those things. Codes of practice. Codes of practice traditionally have provided practical guidance on how to meet the standards set in the Act or regulations. And really they're a tool, information mechanism to help PCBUs comply with specific requirements. They have evidentiary status in court in relation to whether or not a duty is actually being complied with. The main thing to say about codes of practice is that A, they are being progressively introduced as they are developed by SafeWork Australia and after they've been formally adopted in South Australia. However, in relation to the codes, if there's an equivalent or a better way of actually meeting an obligation that can be used instead of the code, and the PCBU can show that's the case, then that's perfectly okay. In relation to penalties, penalties have increased somewhat. The important thing to remember in relation to penalties is that they reflect the seriousness of the matter, and also they relate to the risk and the degree of harm. So in relation to Category 1, whilst those figures seem quite high, there's always been the provision for up to 5 years jail in relation to the most serious of offences, and these offences are offences that have been shown to have been done without any due regard to health and safety and in a recklessly and indifferent manner on the part of the person or organisation who's been prosecuted. The Category 2 offences are those that where there's been a breach and it has exposed people to harm, to risk of serious illness, or injury. And Category 3 offences are breaches that have not necessarily resulted in direct exposure to harm, but nonetheless have been proven breaches of the Act or regulations. That's the end of the presentation. One thing I would suggest to you, though, is that if you've got any questions, you can contact us or visit our website. The number 1300 365 255 is the number for our SafeWork SA Help Centre, and we have quite a lot of information available on our website. We also have a library and bookshop in Victoria Square in Adelaide that you can visit in relation to information about work health and safety in South Australia. Thank you.